several articles came discussing whether secular socialist जो term है they should be part of the preamble or not, whether they were illegally added at the time of emergency and all. तो यहाँ पे ना there have been other news also. You will see in November 2024 a division bench of the Supreme Court led by CJI dismissed pleas challenging inclusion of words socialist and secular. वहां पे भी a plea went to Supreme Court कि socialist and secular word should not be there in the preamble. They dismissed it. तो एक पुराना judgment भी, let's talk about it. तो preamble was only amended once, 42nd Constitutional Amendment Act. What was added? Socialist, secular and integrity. These three terms were added. Now, on what grounds is this being challenged? They say in Supreme Court also, in November, a plea was there. On what grounds is this being challenged? कि you added socialist, secular, ये terms. पहला criticism है that it was inserted during emergency and forced people to follow specific ideologies. So they say that the word secular was deliberately not included by the Constituent Assembly. Constituent Assembly ने secular term नहीं use किया ना. They eschewed it, they ignored it, they rejected it. Similarly, the word socialist fettered the economic policy choice of the elected government. और fettered मतलब बांध के रख देता है. They argued this कि यार the term secular was rejected by the Constituent Assembly and the term socialist in a way restrict the government. You have to have socialistic policies. So what are the arguments which are being given? One, you inserted it at the time of emergency when people did not have an option of opposing it. Two, secular, the term secular was deliberately eschewed. Eschewed means rejected, ignored by the Constituent Assembly, and the term socialist fettered मतलब होता है बांध के रख ले, fettered the economic policy choice of elected government. They also argued that एक बहुत दूसरा argument है. They say that in our preamble, what is the date of adoption? 26 November 1949. How can you make changes there and say कि it is 26 November 1949? You have made changes later. So it is not the same thing that was adopted on 26 November 1949. On these grounds, on these 3-4 grounds, it was challenged in the Supreme Court. What did Supreme Court say? Supreme Court said the terms socialism and secularism are integral to the basic structure of the Constitution. It's part of the basic features of the Constitution. You cannot say that India is not a socialist country, India is not a secular country. First argument that the Supreme Court gave was this. They say that Parliament has unquestionable power to amend the Constitution till the time they do not amend the basic structure. तो जो 42nd Constitutional Amendment Act है, जिसके through what has been inserted? Socialist, secular has been inserted. Parliament had right to amend the Constitution. Even during emergency, they can do that. Then it also confirmed the retrospective amendment to the preamble, saying that date of adoption would not curtail power under Article 368. एक argument ये दिया गया था ना कि date of adoption is 26 November. Now please note that is date of adoption of our Constitution. 26 November 1949 ko we have not adopted the preamble. We have adopted in our Constituent Assembly this 26 November 1949 do hereby adopt, enact and give to ourselves this Constitution. अब हमारा date of adoption ये इसका मतलब है Constitution will not be amended throughout the period. We have had hundreds of amendment in the more than 100 amendment in the Constitution. Yeah, what kind of argument is this? It was adopted on 26 November 1949. So now its date of adoption should not be that. So this Supreme Court also rejected this argument. Then the court said that the Constitution is a living document and is open to changes. It argued that Constituent Assembly was not sure about what secularism should entail in India. What will be the meaning of secularism? Like will it be negative secularism? Ki we will disregard all religion altogether. over time, nation has developed its own interpretation of it. We have developed India's way of secularism, and that's why the term secular can be part of the preamble. So the Supreme Court gave an argument ki why Constituent Assembly did not include secularism and why we can have it now. Second, as per India's interpretation of secularism, the state neither supports any religion nor penalizes the profession and practice of any faith. This principle is already enshrined in Article 14, 15 and 16 of the Constitution, which prohibit discrimination against citizen on religious ground, and this was adopted, this was included there. No, so we cannot say that India is not a secular country. The court also said Preamble's original tenets of equality of status and opportunity, fraternity, dignity and liberty reflect the secular ethos of the Constitution. So Apex Court highlighted neither the Constitution nor the Preamble mandates a specific economic policy. When we use the term socialism, it's about India being a welfare state. It's not saying that government should follow socialistic policy and take over all the resources, means of production. It's not saying that, nor has government tried to do it. So this socialism is not the communistic socialism. जो अपन ने पढ़ा, जो arguments दी, Supreme Court also said this, क्या बकवास लेके आओ, निकलो से. They gave those arguments only. In fact, there are some other arguments. Abhi recently, June, July mein, there have been newspaper articles. They give some other arguments for why India is a secular nation or why preamble mein secular hona is okay. First thing that they say is secularism originates from India's culture even before the constitution existed. They say if you go to the policy of Dhamma of Ashok, what there Ashok is saying that there should be discrimination should not happen among people of different faith. Then it's also one of the ideals of India's freedom struggle. हमारे कॉन्स्टिट्यूशन में बोला है ना, हमें अपने फ्रीडम स्ट्रगल के आइडियल्स को रेस्पेक्ट करना है. इफ यू लुक एट नेहरू रिपोर्ट in 1928, provided state shall neither directly or indirectly endow any religion or impose any disability on account of religious belief or religious status. कराची रेजोल्यूशन जो जिससे स्वराज वाला रेजोल्यूशन आया, वहां पे भी state shall maintain neutrality in regard of all religion. Then secularism is also good for religion. कैसे? देखो अभी just think of this. Suppose some people say that India should be made a Hindu state. गवर्नमेंट का रिलीजन हिंदू रिलीजन हो जाना चाहिए. बट देन गवर्नमेंट विल कंट्रोल रिलीजन. अगर रिलीजन इज ऑफ गवर्नमेंट, देन गवर्नमेंट विल बी कंट्रोलिंग थिंग एंड ऑटोनॉमी ऑफ रिलीजियस इंस्टीट्यूशन, रिलीजियस प्रैक्टिशनर्स इज गोइंग टू गेट अफेक्टेड. रिलीजन रिमेन्स इंडिपेंडेंट एंड ऑटोनोमस अंडर सेक्युलरिज्म. If a religion becomes state religion, the state takes control over the control of such religion. Then secularism is also an idea of modernity. If we move away from secularism, we are going in the medieval time. In fact, the idea of secularism emerged when reason became more important than faith. When rationality became more important than faith. So secularism could triumph in the 18th century because reason triumphed over religion. Then secularism is one of the basic structure of the constitution. Up secularism term, you cannot make India a non-secular country. That will be a violation of basic structure. Any amendment is that kind of amendment is not allowed. And finally, silence of the original constitution on secularism does not mean it did not provide for it. It provided for it. Article 14, 15, 16 made provided. Article 25 to 28 made provided. It provided for the provisions of secularism. It just the term secular was not there in the preamble that was added in the 1976 by the 42nd Constitutional Amendment Act. So finally, in conclusion, we are saying that secularism was implicit from day one and was merely made explicit in 1976.